This is part 2 of training for Ohio Realtors Residential Real Estate Purchase Contract. We will address areas lines 90 through 255 at this time, and that will conclude part 2. Under line 90, number 7, fixtures and equipment. The property shall include all improvements and fixtures now located on the property and owned by the seller. Fixtures shall include, but are not limited to, the following affixed items, if present. So on lines 92 all the way to lines 151, there are many items addressed here that could possibly be on the property, but as it mentioned on line 91, only if present. Moving down to line 152, the following items checked. Equipment is also included, which shall be in the same location, condition, and working order as of the date of the buyer's offer. And this addresses dishwasher, dryer, electric range, freezer, gas range, refrigerators, washing machine, window draperies, wine cooler, refrigerator. That's where you would check any of those that the buyer is asking for or that the seller has already indicated will be staying. On line 164, other included equipment or fixtures not listed above. This would be if the buyer chose to ask for something that had not been listed but would like to make it a part of the purchase agreement, such as a riding lawnmower, a snowblower, etc. On line 165, the following are excluded. Of course, this is where you would write anything you've already been made aware of that will not be included but is affixed. 166, the following checked equipment is leased by the seller and is not included with the property. Appliances, whichever ones those would be that are leased, propane tank, security system, shed, solar panels and accessories, water conditioning system, water heater, or other. Many disagreements arise in determining what is and what is not considered a fixture. Ohio law defines fixtures as tangible personal property that has become permanently attached or affixed to the land or structure. A good rule of thumb is to imagine turning a property upside down, and what stays in place by being attached to the land or structure could be considered a fixture in a court of law. Note, both the buyer and the seller's broker should be careful in reviewing this section to ensure the fixtures and equipment selected are correct. Seller's broker should discuss with their client any items which are leased that are to remain with the property and any fixtures which the seller will be removing, and ensure this contract reflects that fact. In our brokerage, I encourage you to take this purchase agreement with you on a listing appointment, and when you're listing the home, address this section with your sellers under line 90 all the way to line 174. It's a great conversation piece, and that way the seller is certain to understand what a buyer may be asking for or expecting. Moving on, line 175, residential property disclosure. Unless exempt under Ohio Revised Code 5302.30, sellers of real property that includes 1 to 4 dwelling units must provide buyers with a completed Ohio residential property disclosure form. If seller claims an exemption, seller agrees to provide the buyer with an Ohio Realtors Residential Property Disclosure Exemption Form. If the residential property disclosure form is required but is not provided prior to the time buyer enters into a contract to purchase, the buyer may be entitled to rescind the contract. Seller and buyer may consult with an attorney regarding the obligation to provide this form and the rescission rights provided for under Ohio Revised Code 5302.30. Line 180. The buyer has or has not received an Ohio Residential Property Disclosure Form completed by the seller. Notated section. Most, but not all, sellers of residential real estate must provide a completed and signed real property disclosure form to buyers. It is recommended that seller's broker arrange for the seller to complete the form at the time of listing the property and make the form available to interested buyers prior to entering into a contract. For sellers who are exempt from providing the disclosure form, Ohio Realtors has provided an exemption form for members' use indicating that the seller is exempt and the applicable exemption. Notwithstanding the foregoing, being exempt from the use of the disclosure form does not relieve a seller from their statutory or common law duties to disclose material defects. Note, if prior to entering into a contract, the seller learns of a defect in the property from an inspection or otherwise, the seller should amend and re-execute the disclosure form by providing any negative inspection report to subsequent buyers. Failing to provide this disclosure form or amending the form after entering into a contract could provide the buyer with an immediate right of rescission. Seller should be referred to legal counsel if seller has any questions regarding a duty to disclose or providing an amended form. Okay, a couple things here I'd like to point out. And one is I would appreciate if you have a seller who is dragging their feet on filling out the residential property disclosure form or states that they are exempt, all of those things, I would suggest you address lines 175 through 179 with your potential sellers at the time of a listing. And we in our brokerage do have this document that they are talking about. It's Ohio Realtors Property Disclosure Exemption Form. It is in our templates for you to use with those that feel they are exempt. As a listing agent, it's also your responsibility to be certain that these are provided to a buyer's agent prior to an offer being written. We recommend you upload them into the supplements of the MLS so they are available, because as you read here, you can see that buyers may have an opportunity to rescind if they don't receive them. And to put your seller in the best position possible, you don't want them to necessarily have that opportunity for the simple matter of not providing those in a timely manner. So please be certain that those are there and uploaded. And in the section where it mentions if the seller learns of any additional information, they need to update the residential property disclosure form that they've used. Not only if an inspection identifies something, but if something were to change on the property from the date of execution to the date of closing, such as even as simple as replacing a hot water tank, that is a change that was made, so that will need to be amended on that residential property disclosure form. Lines 181, inspections and tests. This area is somewhat different than what we have been practicing with in the past, so please pay attention in this area. Again, there are some dates to be wary of. And again, anytime throughout the purchase agreement where you see bold font, and particularly bold font and capital letters, those are areas that you definitely want to address with your clients. 181, number 9, inspections and tests. The broker strongly recommends that the buyer conduct inspections and or tests of the property and its components. Buyer understands that all real property, fixtures, and equipment may contain defects and conditions that are not apparent and which may affect the property's use, value, or safety. Buyer and seller agree that the broker does not guarantee or assume responsibility for the condition of the property. This is where it changes. The buyer is going to have two different options here that we've not had in the past. So on line 185, 9A, the parties agree that the following inspections and tests can be performed. Number 1, any inspections and tests desired by the buyer at the buyer's sole discretion. So if the buyer were to check this box here, they don't have to identify the inspections that they plan to have. 187 or 188, number 2, this option, the following marked items. 189 through 200 identify individual inspections that a buyer could choose to have. Please note that under no circumstances could line 186 and any of the ones below it all be checked. That would be conflicting information. If they check 186, they don't have to identify anything else. If they don't check 186 and they start at 189, they'll choose the inspections that they want. 201, in addition to the foregoing marked items, the buyer shall have the right to perform any additional inspections recommended by an inspector based on the results of an inspection selected above. Such additional inspections shall be performed within the inspection period, other than those recommended by an inspector based on the results of an inspection selected above, If the buyer does not select an inspection listed above, the buyer waives the right to have that inspection test performed. Note, in some areas of Ohio, purchase contracts and local custom allow buyers the opportunity to identify specific inspections a buyer wishes to conduct, whereas some contracts simply allow buyers any inspections they want. Both options have been provided above. Again, please note that in sections lines 201 to 204, those are addressing the areas of line 189 through 200. So if, for example, your buyer only checked a general home inspection and a radon inspection, but the licensed inspector detected some mold, the buyer is able to get that inspection done because the licensed inspector pointed it out to them. Okay? Line 205, 9B. This is also somewhat different than what we're used to, so please follow along. Inspection period. Inspections and or tests must be completed no later than, however many days, 10 days if left blank, from the date of acceptance of the contract, which is considered the inspection period. If the buyer does not complete an inspection test during the inspection period, that inspection shall be deemed waived. 208, 9C. This area, for you all to know, it is called the request to remedy or termination, which is also considered part of our ROC, what we're used to using. Again, we have bold font here under 208 with capital letters. Buyer may only terminate this contract for material defects, which includes, but is not limited to, those defects or conditions which may impact health, safety, habitability, use, or value of the property. Buyer may not terminate this contract for non-material conditions such as routine maintenance and cosmetic issues. Line 211. If the inspections or tests identify material defects, buyer may, on or before the end of the inspection period, either terminate this contract or provide the seller with a request to remedy the defects. Again, please notice, request to remedy in our office is the removal of a contingency document. A notice of termination or request to remedy must be delivered in writing to the seller or the seller's broker and must be accompanied by a copy of the relevant pages of the inspections, tests, or reports specifying the material defects. Failure of the buyer to provide a notice of termination or a request to remedy on or before the end of the inspection period constitutes the buyer's acceptance of the condition of the property and shall be a waiver of the buyer's right to terminate pursuant to this provision. Line 216. If the buyer delivers a request to remedy any material defect not previously disclosed by the seller, the party shall have blank days, 3 days if left blank, to reach a written agreement, which is considered the remedy period. The remedy period shall end upon the party's execution of a written agreement regarding the requested remedy. Again, for our office, that would be the removal of contingency document. Line 218. If the parties do not enter into a written agreement by the end of the remedy period, this contract shall terminate, unless the buyer withdraws the request to remedy in writing prior to the end of the remedy period. Nothing in this section precludes the buyer from terminating this contract by delivering written notice to the seller before the expiration of the remedy period. Upon termination, the EMD shall be dispersed pursuant to paragraph 6 regarding earnest money. Number 222, 9D, License Inspector. If a home inspection, as defined in Ohio Revised Code 4764.01, is conducted, it shall be performed by a home inspector licensed by the Ohio Department of Commerce. Pursuant to Ohio Revised Code, Chapter 4764, an inspection or test of only a specific single component of the property may be performed by a qualified or credentialed professional in that field who does not perform an entire partial home inspection outside their area of expertise or credential. Buyer assumes the sole responsibility to select and retain licensed and qualified inspectors and releases the broker or any liability regarding the section retention or performance of inspectors. 227, inspection costs. The buyer shall pay the costs of all inspections and or tests. 228, 9F, point of sale inspections. Unless otherwise agreed to in writing by the parties, seller will deliver the property point of sale compliant prior to title transfer if required by local law. And 230, 9G, damages. The buyer shall be responsible for the repair of any damages caused by the buyer's inspections and tests. Repair shall be completed in a timely and workmanlike manner at the buyer's expense. Note, the buyer's broker should pay extra attention to the provisions of Section 9 with respect to the choice of inspections, the time for the buyer to conduct said inspections, and complying with the terms for requests for remedy or termination. If the buyer fails to provide a notice of termination or request for remedy before the end of the inspection period set forth above, then the buyer is deemed satisfied and accepts the condition of the property, and the contract remains in effect. Home inspections must be performed by a licensed home inspector. In some areas of Ohio, local government entities require point-of-sale inspections, which can create conflict with respect to timing and cost for repairs. Both brokers should take this fact into consideration when working in a jurisdiction that requires point-of-sale inspections. I'm going to revisit this area for a few seconds here for you. And one of them is under line 205-9B. Please know the property type that you're working with for inspections you might be getting, and your buyer's schedule for availability to have an inspection done, and also for them to be able to receive that information, review it, and make a request if they would be wanting some type of repairs made. Because in this section, you shouldn't, if you put in here, inspection period and test should be completed no later than, let's say, 7 days from the date of acceptance, you will have to have received all of that information for your buyer to make their decision no later than 11:59 p.m. on the 7th day. They have to have made their decision. So it wouldn't be prudent to have inspections done on the 7th day if they choose an inspector who says it will take 2 days to get them the report. So you can put any number of days in there that the buyer deems necessary. Just know the property type that you're working with and your buyer's availability to be able to get back to them on time. Okay? So that addresses that area there. Also notice that in 230-9G, the buyer shall be responsible for the repair of any damages caused by the buyer's inspections and tests. Repair shall be completed in a timely and workmanlike manner at the buyer's expense. Just another reason why it's very critically important that buyers attend these inspections and that they follow the inspector around the house, because they will be responsible for the inspector that they chose if they should cause any damage. Moving on to 232, lead-based paint, number 10. With respect to housing constructed prior to January 1st, 1978, the buyer must be provided with the pamphlet entitled Protect Your Family from Lead in Your Home and the form Disclosure of Information on Lead-Based Paint and or Lead-Based Paint Hazards. Every buyer of any interest in residential real property on which a residential dwelling was built prior to 1978 is notified that such property may present exposure to lead from the lead-based paint hazards that may place young children at risk of developing lead poisoning. A risk assessment or inspection for possible lead-based paint hazards is recommended prior to purchase. Line 237, for housing constructed prior to 1978, line 238, the buyer has or has not received the seller's disclosure of any lead-based paint or lead-based paint hazards known to the seller on the property. Line 239, buyer has or has not received the pamphlet Protect Your Family from Lead in Your Home. Just let me point out here that on line 239, it is your responsibility as an agent in our office to provide that pamphlet, Protect Your Family from Lead in Your Home, and it should be included in the loop that you're sending to your buyer or have been submitted to them in your buyer consultation appointment. On line 240, this is more lengthily involved than we've had in the past, so please pay pertinent attention to it. Sex offender registration, off-site conditions, property use. Ohio's sex offender registration and notification law requires the local sheriff to provide written notice to neighbors if certain designated sex offenders reside or intend to reside in the area. Buyer assumes sole responsibility to obtain information from the sheriff's office regarding the registration of sex offenders. I, as the broker, encourage you to direct your buyers to look that information up themselves on the sheriff's website of the area they're purchasing. Please do not do that for them, but allow them the opportunity to do that themselves and recommend that to them. A continuation of line 243. Buyer acknowledges that the buyer has conducted investigations regarding the municipality, zoning, school district, and use of the property and conditions outside of the boundaries of the property, included but not limited to crime statistics, noise levels, i.e. airports, interstates, environmental, odors, local regulations, developments, or any other issues relevant to the buyer, and has verified that the property is suitable for the buyer's intended use. The buyer assumes sole responsibility for researching such conditions. Notwithstanding anything to the contrary, the seller makes no representations or warranties regarding these conditions and the use of the property. The buyer acknowledges that the buyer has been given the opportunity to conduct research pertaining to the foregoing prior to execution of this contract. Buyer is relying solely on the buyer's own research, assessment, and inquiry with local agency and has not relied on seller or brokers involved in this transaction. Note, this purpose of paragraph 11 is to put the buyers on notice regarding not only the possible existence of registered sex offenders in the area, but to also address other off-site conditions that the buyer may be concerned about and that may impact their use of the property. This language is intended to protect the brokers and seller from litigation by placing the burden on the buyer to conduct their own due diligence regarding these issues. And again, I would like to point out that in our brokerage, I am requesting that you not provide your buyers with the information for these situations, and that you yourself direct them to the entities that they could go to look at, but make recommendations only. Please do not provide them with any of this information, as you may not provide them with everything that they're looking for, and it is their responsibility to find that out. Line 250, number 12, seller's cooperation. The seller agrees to make the property available at reasonable hours for access by brokers, buyers, inspectors, licensed appraisers, and other authorized persons as required to satisfy the terms of the contract. The buyer acknowledges that the buyer and other professionals are not authorized to be present on the property without a real estate licensee unless prior express written authorization is given by the seller. 254. All utilities shall remain on until possession is delivered to the buyer, except utilities that were turned off at the time of showing. However, the seller agrees to have all utilities turned on for inspections, tests, and appraisals. Please note this important area. The bolded language reflects the position of the Ohio Real Estate Commission, allowing such persons access to the seller's property without a licensee present and without the seller's authorization has become a top area of discipline. The general requirement is that utilities must remain on until possession is delivered to the buyer. This paragraph does not create one exception, namely the instance where the utilities are turned off at the time of the showing, usually because the property is vacant. This section clarifies that in this situation, the utilities must remain off, but are required to be on for the inspections, tests, and the appraisal. I would like to revisit this for a moment, and that is line 251 through 253, the bolded font. The buyer acknowledges that the buyer and other professionals are not authorized to be present on the property without a real estate licensee unless prior express written authorization is given by the seller. As the broker of this brokerage, I want to impress upon you how we would like that handled. moving forward, if an appraiser contacts you and asks access to the home to do the appraisal, if you as the listing agent will not be present, I request that you call the seller, ask the seller if the licensed appraiser has authorization to enter that house without you as the licensee or without the buyer's agent as the licensee. And if they give you permission, then please follow up with an email to your seller that states something such as, per our conversation, you have given us the authority to give the lockbox code to appraiser so-and-so from such and such company who will be accessing your home for purposes of the appraisal. Then please upload that into your loop so that we have proof that the seller had given permission. The same would be true for a home inspection. Please, when the buyer's agent contacts you regarding the inspection, if you don't already do this, moving forward, the first question you should ask is, will you, as the buyer's agent, be present for the inspection? If they were to say no, then you would ask, would any other representative from your brokerage accompany the buyer? If they say no, then you say, I have to get written permission from the seller allowing that inspector and that buyer to go into the home if there will be no licensed agent. And again, same protocol. Contact the seller, ask them their opinion. If they agree to give the lockbox code out, that's absolutely fine. It is the seller's prerogative, but we would like that in writing, that you conveyed that back to the seller per our conversation. You've given permission for such and such inspection company and the buyer to enter your property without their agent present. This concludes this section, Part 2, lines 90 through 255. Again, I would like to impress upon the fact that I am giving information for our brokerage's purposes, Keller Williams, Greater Cleveland Northeast. If anyone else should be using this recording as training for themselves, if they are not a part of our brokerage, and you have any questions regarding this language, please consult, or your policies of your own brokerage, please consult with your own individual broker or manager to see if that's how your brokerage will be handling things. Thank you.